Hello everyone, my name is Jeff Tomczak and I have the privilege of being your state's attorney, and welcome to Will County Justice. This is going to be our first episode, so I'm going to ask everyone if they would to bear with us. But what we'd like to do with our show every month is to provide some real life issues to our citizens of what occurs at our courthouse and important issues of criminal law related to our county. Our issue today, and I think it's a very important issue for us to address in our first show, is DUI prosecutions. We have with us today Captain Kevin Shaughnessy of District 5. He is in charge of enforcement for a three-county area of Will, Grundy, and Kendall County. As we began our term in office, it was the most important issue to our office is to address the issue of DUIs. We saw there was a situation developing in our county where the court cases that were being handled were not being handled appropriately, in my estimation, and we felt that bringing the DUI issue out front in our first show is our most important issue to bring forward. I'd like to introduce Captain Kevin Shaughnessy and ask you if you could tell us a little bit about your background.
Thank you, Jeff, and thank you for having me on your first show here. I'm captain with the Illinois State Police District 5, which is located in Lockport, Crest Hill, actually. Our jurisdiction is Will County, Grundy County, and Kendall County. We've got about 50 troopers, 50 officers that work under my command, and they're involved in the enforcement of traffic laws and really any laws in Illinois throughout our area.
How long have you been in law enforcement?
For 24 years.
And what kind of positions have you held besides the one you have right now?
I've been very fortunate to hold just about all different types of positions in operations. My whole career has been in the field. I came to District 5 about 2.5 years ago. Prior to that, the rest of my career was spent in Cook County, District Chicago. Prior to that, District 4. I have a very extensive background in investigations and feel quite pleased to have that background to assume the command here in District 5. I feel very capable of handling all the challenges that come my way.
Captain, I want to ask you a question since the focus of our show today is the DUI issue. I want to ask you, in your 24 years out on the street as a trooper, was there ever one particular incident or a type of case which you confronted as a street police officer which really had an impact on your feelings about the DUI issue?
Well, in thinking about that question, obviously there have been many incidents where you're out there coming in after the fact and seeing the carnage and the real horrific impact that DUI has on families and victims. And one comes to mind. When traveling down the road, I observed a vehicle in front of me leave the roadway, go onto the shoulder of the road, then into the little berm area, come back onto the roadway, lose control, flip over. 3 of the 4 occupants were ejected from the vehicle right in front of me, and 1 in each lane, critically injured. The vehicle came to rest on its roof, beer cans all over the place. That was the first and really only time where I actually observed a crash of that nature, and it did have, I can still see it in front of me today.
I can imagine. I'm sure the families are still feeling the impact of what happened that day. Let me ask you a question. How has the investigation of DUIs changed in your 24 years as a police officer?
In my opinion, the investigations of DUI cases have become more professional. We've taken out opinions and conjecture and how some officer may perceive things, and we've made it rise to a higher level. We've used scientific evidence. We have things now to our advantage in the investigation of DUI, which really allows other people, including the juries and the judge, to see what we see and to come up with, their conclusion.
There's some new technology which is being used in the prosecution and the investigation of DUIs, and I think you brought one of the examples with us. Could you tell us what you have with us?
This is a PBT, portable breath test, and this is used by officers out in the field to give them an indication of the alcohol content on an individual's breath. It's one of many things, or several things I should say, which are used to identify an impaired motorist.
And so the idea would be a trooper could pull an individual over and right there on the scene have an accurate breath test if the person sees fit to provide the sample, correct?
Yes, sir.
Okay.
That's correct.
And those are certified machines, certified by the Department of Public Health?
Yes, they are.
Okay. Now, I understand that there's some new breath tests, breathalyzer machines. Now, if you give a breath test out on the scene, through a PBT, a portable breath test, you're not necessarily done providing samples then, isn't that correct?
That's correct.
Tell us what happens.
Well, if I could begin with the initial reason for a stop.
Right. Well, as far as the breath test itself is concerned, you have a machine down at the station, which when a person is arrested, they go blow into that second machine.
Correct.
And that's an Intoxilizer 5000?
That is correct.
And that machine, that particular sample is then admissible in court, is it not?
Yes, it is.
Captain, you alluded to the fact that there's some video that's being shown in court now, and a lot of our citizens are familiar with the Taylor Pierce Project and how the parents of a child killed in a DUI accident did so much to get cameras into our squad cars. Tell us how that camera project has changed your investigations of DUIs.
Well, having the advantage of a camera in the squad car automatically enhances the credibility of our officers. It's a decision that a judge or a jury can make what the officer sees, whether or not they would formulate the same conclusion about what it is that we see. So what we found is that by having that video camera in the squad car to show field sobriety testing, to show the driving violations that the officer also sees, when it's played back in court or played back to the defendant or his attorney, many times the decision is made, we don't really want to try and fight this, we're going to face up to what we did and accept what we have coming.
And we are finding on our end that there is an increase in plea bargaining percentage-wise when we have a camera project case before us. It is, you're exactly correct, it is helping. And it also provides for the judge a true scene of what happened, both good and bad. If someone did pass the field sobriety test, well, that's going to be on the camera. If they failed, the camera will pick that up also. And that's what you guys are finding.
Yes.
What I wanted to do with this half of the show is to kind of provide to the citizens an indication of from the arrest all the way through to the prosecution of what would happen to an individual if they were to become caught up in our system and caught driving drunk in your district. And what I'd like to start off with is, we hear the term probable cause being used all the time. Could you provide our listeners with some indication of what types of probable cause or what indicia of probable cause your troopers are confronted with in a DUI case?
Okay. When a trooper is out there on the road observing traffic, whether he's sitting on the shoulder, whether he's on an entrance or exit ramp, or he's driving in the flow of traffic, he's monitoring the traffic for violations. He many times has a radar unit in the squad car activated. He's monitoring speed. Quite often individuals come by at an excessive rate of speed. That's the first indication. Obviously there's a violation there. The trooper pulls out, gets behind an individual. He continues to monitor the individual who was speeding or the violator. He may at that time, not only in addition to speed, he may see another violation of hugging or straddling the fog line, weaving in traffic, not maintaining a constant position within a lane. He may see a couple other things which would indicate that obviously there might be some problems with the driver being in control of his vehicle.
And there are certain types of vehicle offenses which are indicative of a person unable to control their vehicle, and you've mentioned some. Improper lane usage. If you're unable to drive straight down the roadway, that shows a loss of control of your vehicle. Right. Someone who might go through a stop sign. Right. Someone who might not see a certain signal in the roadway, that would be indicative of someone who would be impaired, and it's affecting their driving. And that's what the troopers are looking for.
Yes, sir. That's correct.
Now, in accident cases, I mean, I suppose occasionally the troopers are going to pull up on an accident case where you have, where the accident's already occurred. What types of probable cause are we looking for in those circumstances?
Well, many times they're obvious because there's open containers of liquor that are on the scene. If a car is involved in a crash, there could be a open can of beer. There could be the smell of alcohol inside the vehicle from liquor spilling during the crash. The apparent odor of alcohol from the driver. Those are things which really are apparent at crash scenes.
Now, we also see the field sobriety test, the touching your nose and the one-leg stand test. Could you tell the listeners a little bit about how those tests are used and how important they are to your investigation?
Those tests are administered to determine the level of impairment, if any, in an individual. Because an officer detects the odor of alcohol on an individual's breath doesn't necessarily mean that they are impaired. So the field sobriety tests allow the officer to make a determination based on the skills which an individual should have in a sober state to determine whether or not they're impaired.
Okay. And the troopers are trained in performing those tests, correct?
Yes, they are.
Right, now I'd like to move our defendant, for lack of a better term, back to your station now. Could you tell the ladies and gentlemen a little bit, because I think some folks don't really appreciate it. It doesn't matter who you are, whether you're the president of a corporation or you happen to be a laborer. When you get arrested for a DUI, certain things happen to you. Isn't that a fact?
That's correct.
Could you tell the ladies and gentlemen a little bit about that?
Well, after you're arrested, you are placed in handcuffs. You're searched. You're placed in the back of the patrol vehicle. Many times, depending if you're out there on the highway, your car is towed. You are brought back to the police station, led into our headquarters in handcuffs, back to our processing room. Many times you'll travel through the hallway where there could be individuals there for business not related to crashes or anything like that. They're led into a processing room where they are actually secured to a holding area within our headquarters.
Okay, and then they go through the process of booking, and it doesn't matter who you are. You're fingerprinted, you're photographed, and there's entries made in a national crime computer, isn't there?
That's correct.
Okay, so it really presents a situation where you're a permanent record being created of your DUI arrest. Isn't that a fact?
Yes.
Then you ask him to take a breath test, and that machine is right there at the zone, isn't it?
Yes, it is.
Now, how often, and one of the things the prosecutors really don't see is how often do you get an individual, percentage-wise, that will take that test versus will refuse to take the test? And has that changed over your career as a policeman?
Well, I think it has changed. I think less are taking the breath test now. I think they're influenced by other factors not to take the breath test. However, a surprising amount of individuals who appear to be obviously impaired will take the breath test to prove, in fact, they're not impaired. So just a guesstimate, 40%.
Well, it's an interesting note for us prosecutors, and not a lot of people realize. They think if they don't take the test for some reason, some evidence is not going to be presented. But the fact is, Captain, that when an individual refuses to take a breath test in court, that evidence is admissible against them. And the way our prosecutors, and we have one coming up behind you here, the way our prosecutors will argue it is, having been presented with the breath test, standing there in front of the intoxilizer and being asked to take the test, the defendant is asked a question that he has to answer in his own mind. And that question is, am I intoxicated? Will I pass this test? And when that defendant looks at the machine and very humbly turns to you and says, no, I'm not going to take that test, we argue in court that that is the best evidence. That's the defendant's own evidence admitting that he believed he was intoxicated at that night. So it's an interesting twist. A lot of guys think they're getting kind of away from things if they don't take that test, but the way it's used in court is it's devastating evidence against a DUI offender. Is there anything that you've confronted? I want to end on, we have a minute left here between ourselves. Is there anything that you remember, a funny instance or some kind of funny experience that you had out there in your 24 years and not necessarily involving a DUI case?
Well, many times in dealing with drunks, it's humorous on the surface, and we'll laugh because they can't speak properly. The simple task we take for granted, they can't do. Maintain a balance. A stumbling drunk. You know, just on the surface, there are many times, you know, it's humorous. However, past that initial dealing, we realize that, you know, that humor is short-lived because the effects of their drinking and driving many times cause injury or death to innocent people. But it is at times humorous with people's reactions to the police and the excuses they make. It's many times, for a moment you get a chuckle and then it's right back doing your job.
Well, Captain, thank you so much for providing us with your input, and I'm sure I'll be seeing you out of court.
Thank you.
Thank you. Okay, we'll be back shortly. Welcome back, everyone. We have the second part of our show this month, and we have Tom Conzel, who is an assistant state's attorney and the chief of our misdemeanor and aggravated traffic division. As I said earlier, what we're continuing to do is to try to provide the citizens with a DUI case from arrest all the way through the prosecution, so there can be an understanding of what happens in our court system. I also want to note, as the state's attorney of the county, that we have an individual here in Tom Conzel, a person who is a career prosecutor, someone we can be proud of, somebody whose work has resulted in, according to the Herald News statistics, 187% increase in the number of DUI convictions in our county, and an overall increase of 55% in the number of cases that we're prosecuting. And that having been said, Tom, we're very proud of the work you've done over there. Could you tell our citizens a little bit about your background?
Well, I have a chemistry degree from Loyola University a long time ago, back in 1970, which at least helps me in the presentation of scientific evidence. And from there, I became a Chicago police officer in 1970. Between 1970 and 1980, I was a Chicago police officer and then a Chicago police detective. After that, in 1980, going to law school at night during my police career, I became a Cook County State's Attorney in 1980 and spent 20 years with the Cook County State's Attorney's Office, during which time I did traffic court, misdemeanor court, and spent a great time in felony court, all the way up through a first chair, which is the head of a felony trial courtroom. And then I became the chief of, or the head of the forfeiture division for the Cook County State's Attorney's Office, and I retired from the Cook County State's Attorney's Office in August of 2000 after another 20 years there. And then I became an assistant state's attorney in Will County in August of the year 2000.
Okay, and as our administration started, you were promoted to head up the DUI division, didn't you?
Yes, I was. Thank you.
All right. Now, one of the issues I want to talk about, and they really don't involve prosecutors so much, is prior to one of your defendants hitting your courtroom, they go ahead and they have to hire somebody, don't they?
Yes, they do.
And how often do you see individuals charged with DUIs that are represented by counsel versus pro se, which would be representing themselves?
Well, because a DUI case involves a jail penalty of up to a year in the misdemeanor sense. In felonies, they can actually go to the penitentiary in a felony case. Because of the DUI jail sentence involved, they actually don't go pro se. They would be assigned a public defender, and to qualify for the public defender, they would have to be indigent. I would say probably in the DUI sense, more than half, if maybe closer to 2/3 of the individuals who are charged with DUI do retain private counsel at their own expense.
And about 2/3 of those individuals that are charged with DUI then are going to have to pay out thousands of dollars for a lawyer.
Yes, they do.
Okay, and then that lawyer's the guy that you're fighting when you're in court, isn't it?
Well, I
Not
guess
fighting with?
Fighting.
Okay, all right. Now,
he's our adversary, yes.
let's tell the viewers a little bit about what happens. How many court appearances, what happens at the first court appearance for a defendant, and about how long does the case take, generally speaking?
Well, there are two simultaneous things that can be happening to a defendant. The first thing is his arraignment, his first court appearance. That usually takes place between 15 and 52 days or 50 days after the arrest. At that court appearance, he either enters a plea of guilty or a plea of not guilty, and then usually a pretrial date is set. One of two things can happen. Either a defendant can decide at that point with his attorney that he's going to plead guilty, and prior to pleading guilty, he's required to undergo an alcohol evaluation to determine his likelihood of recidivism in alcohol, what his past alcoholic history is, what type of treatment it would be required, because treatment will be one of the things that will be mandated in the plea of guilty. Normally, we give him a month to 2-month continuance so that he can go to the evaluators, get the evaluation, have it prepared, and returned to him and to the court.
Now, let me make it clear to the viewers there. So what you're saying is every single person that is charged with a DUI, whether they are ultimately convicted or not, is required to obtain an alcohol evaluation. Isn't that correct?
Well, if they go to trial and are found not guilty, then, of course, it wouldn't be necessary because there's going to be no sentencing. But anyone who is either pleading guilty or being tried and found guilty It is a statutory requirement that they do get an alcoholic evaluation prior to sentencing so that the judge, the court, can consider his alcoholic background, if you want to call it that, in determining the proper sentence for that defendant.
Now there is another reason to get an alcohol evaluation prior to trial, and that's because of judicial driving permits and other ways that your license is affected. I'd like you to take a minute to talk about the statutory summary suspension, what that means for an individual charged with a DUI, and then how the suspension is attacked, I guess would be the way to put it.
Okay. That was the second thing I was talking about at the beginning. The first thing is the actual arraignment and criminal trial. The second is a statutory summary suspension. This has to be requested by the defendant. What happens at the time of arrest is that he is offered the opportunity to take either a breath, give a breath sample to the police in an intoxilizer, or he is given an opportunity to give a blood and urine sample. The police department chooses which, under the circumstances of that arrest, they wish to have the defendant do, and the defendant's mandated to do it because driving in the state of Illinois is not a constitutional right. It's a privilege. And one of the requirements of that privilege is that if there is probable cause to believe you're driving under the influence of alcohol, the officer has a right, in fact a duty, to ask you to take a breath or a blood and urine test. You have the right to refuse that test. If you refuse that test, then you will be given a 6-month statutory summary suspension. In other words, you will lose your license for 6 months. If it is the second time you've refused it, I believe that goes up to a year and then becomes even greater with multiple refusals. If you take that test and pass it, of course you probably will not be written a DUI ticket. However, if you take that test and fail, the suspension is only a 3-month suspension instead of a 6-month suspension. The reasoning, I guess, for that is that at least you have cooperated and taken the test. If you cooperate and take the test and fail, or if you refuse to take the test, you get the 3 or 6 month suspension. That's done by the Secretary of State based upon a form that the police department sends to the Secretary of State. You will be notified in the mail that your license is going to be suspended and what the suspension date is. Usually 45 days. The suspension usually begins 45 days after the date of arrest. You have an opportunity to have a judicial determination as to whether or not that suspension should go into effect. It's called a summary suspension hearing. You have to apply for that summary suspension hearing, and if you do, we get notice of it as the state's attorney's office, and we will set a hearing date for you. And in that hearing date, you have to attack either the probable cause for the arrest, the fact that you took the test and passed it, or other factors that would lead the court to believe that that suspension should be rescinded.
Let me ask you a few questions as far as being in the courtrooms every day in our county. What are some of the factors that the courts or the judges are looking for as to increase the seriousness of our DUI offenses? In other words, what would be a more aggravating type of case versus the other cases that are run through the office?
Well, clearly the simplest case is a first-time offender who has been arrested for a minor traffic violation, speeding, weaving, running a stop sign. The officer pulls him over, and in fact, this is his first offense. He is actually eligible for supervision. Supervision means he will be fined, he will be given a period during which he can not violate the law, and at the end of that period, the charge is actually dismissed against him after the end of the supervision period. The driver's license is not suspended or revoked because the supervision is not reported to the Secretary of State. You're only allowed to do that one time in your entire lifetime. So the moment you get a supervision for a DUI, that is it. 10, 20 years later, you are not entitled to another supervision.
And you are now getting cases of individuals with 20-year-old, 25-year-old prior DUIs, and you're not in a position where you can offer supervision in those cases?
Absolutely. For the DUI conviction cannot result in a second supervision.
Now, I want to make one thing clear for the viewers. If you drive on a suspended or revoked driver's license, are there any special sentencing provisions that apply to you? In other words, if we take an individual, we say, hey, you're revoked, don't drive. What are the penalties if an individual does go ahead and start to drive?
Well, the first time he's arrested for driving on a suspended or revoked license that is based upon either a DUI, which would be the revocation, or a statutory summary suspension period, which would be a suspension. The first time, it's a misdemeanor, a Class A misdemeanor. You could go to jail for up to a year. The second time you are arrested, it is a felony. and you could go to the penitentiary.
Now, I want to move on a little bit to talk about some new things that we've started in the DUI courtrooms. Could you tell us a little bit about interlocking breath devices? Now, I understand there's a device which actually a person can have put in their car, which requires them to drive only in situations where they're not consuming alcohol. Could you tell us how are we using that device in court?
Well, it is the policy of the Will County State's Attorney's Office that in cases where either a PBT, which is the portable breath test you've talked about earlier, or the intoxilizer breath results are greater than 0.15, we ask the court in either a conviction in which supervision is going to be granted, meaning the license will not be revoked, or if a judicial driving permit is going to be issued by the court, we ask the court to make a part of that order that the defendant have a, it's called a BAID device, a blood alcohol, I forget what the exact terms of it are.
Interlocking device.
Interlocking device. We ask that that be installed in the defendant's vehicle and any vehicle that he drives.
Okay.
What happens is, with that device, he must actually blow a sample of his breath into that device in the car because it's built into the ignition system. And after blowing into that device, if it shows no alcohol in his system, then the car will allow itself to be started. The ignition system will work. If, in fact, there's alcohol in his system, not only will the car not start itself, in other words, the key will do nothing when you turn the key, but it will actually record that instance. And as part of the court order, he has to have it every 3 months, the results of that machine be turned over to the court for evaluation.
So the judge will know that there was a attempt to drive a vehicle with alcohol in the system.
Absolutely.
Now, we have about a minute to go here. You have combined your talents and forfeitures with your job as the DUI chief, and I'd just like you to take about 15 seconds and tell us about what are we doing as far as these multiple DUI offenders that are continuing to drive their vehicles?
Well, a couple of years ago, the forfeiture statutes of the state of Illinois were amended to allow for the forfeiture of vehicles. That means actually the seizing by the police department and the court-ordered turnover of that vehicle to either a police department or a state's attorney's office or the state of Illinois. In other words, you lose your vehicle, your right and title to that vehicle to the state for certain offenses. And those offenses now are a third or greater DUI when you are driving on a normal license. In other words, your license is valid. And you commit your third DUI, including supervision. So your third or greater DUI, you lose your vehicle. And if you are currently suspended or revoked for DUI, then you lose it the second time you drive. So if you are picked up on a second DUI while you are currently suspended or revoked, not only is that a felony, but you will also lose your vehicle to the state of Illinois.
Well, Tom, thank you for coming in and sharing your background with us and your work, and we appreciate your hard work. And thank you, viewers, for listening. Next month, we're hoping to cover issues related to the juvenile problem in our county. Thank you.